This is being recorded, so if anyone comes in late, they'll be able to watch. Welcome to our really exciting event, Solving the Initial Appearance Crisis. I'm Pam Metzger. I'm the director of the Deason Center, and we are thrilled to have you join us. Let's go ahead and jump right in. Let me begin by just telling you a little bit about the Deason Center. We're a policy and research center located at the SMU Dedman School of Law, and we have really three areas of focus. Our first area of focus is the right to counsel. We study public defender systems, private appointed counsel systems, the quality of the right to counsel and the way it's delivered, caseload studies, access to counsel, you name it, we're interested. Second area of our focus is our STAR criminal justice campaign. This is our work on behalf of small tribal and rural jurisdictions. In this space, we have a lot of programming, drawing attention to the unique challenges and the unique opportunities in STAR justice. In fact, we have a great event coming up on diversity in STAR justice communities. But it's also a place where we do a great deal of work on the delivery of public defense and the right to counsel. And finally, in a topic that I think will become increasingly relevant to this conversation as our campaign goes on, we work on issues of prosecutorial discretion, narrowly confined to questions about how prosecutors make their charging decisions. So having talked about that a little bit, let me share a little bit of our philosophy. Our sort of catchphrase is stats, stories, change. And I want to try and explain what we mean by that, because that really tells you a lot about this campaign. For starters, what we are is we're an interdisciplinary team. Many of you will know our chief data scientist, Dr. Andrew Davies. If you're on IDRA or any public defense advocacy groups, you know that. We have a full team of data scientists, as well as lawyers, communications experts, and we try and come at these issues from an interdisciplinary perspective. Secondly, we are really focused on the real world, by which I mean people, practice, and systems. We're engaged with system-impacted individuals as well as stakeholders. We're interested in how things work and don't work, as opposed to maybe what the ideal might be. And we're interested in thinking about systems improvement and system design to better serve people with improved practice. And what that leads us to ultimately is actionable conclusions in our research design. Every research project we build is designed with the question of what is it good for? This is not a place where we're going to learn about what Aristotle thought about criminal law. We're going to be talking about what it is that research can do to improve the system or improve the experience of people who are system impacted or downsize that system. And so really what we're talking about here is research for reform. That's our goal. So having said that, I want to talk about what we're doing today. I am thrilled to announce that we've uploaded today a new report, our initial appearance report cards. We've put a QR code in here. We're very fancy now. You can take a minute if you want and download it. I'll say to you what I say to my students: don't read it now, read it later, but please do download it. We're going to be talking about it today. It is a labor of love. I am so incredibly proud of the work our team has done on this. So let me jump in and tell you what this project is about before I hand it off to the real experts. This project actually has its origins right about 2001, to be perfectly candid, when I left what had been my prior practice, mostly in the Eastern and Southern districts of New York. After a brief stint in Virginia, I moved to Louisiana, where I was simply shocked to discover that you could get arrested and be held in custody based only on a complaint, only on a probable cause statement, for 60 days. And on the 60th day, if a prosecutor hadn't looked at your case, hadn't decided whether to indict you, they had to release you. In Louisiana, it's called doing DA time, although it could just as well be called doing cop time, because every police officer knows that they can have you locked up for 60 days if they want. And it kind of made my head explode, because we really only know the law that we know. And having been a federal public defender, I had kind of a warped view maybe of what the rest of the world looked like. As time went on, and I was living and working in Louisiana, began to travel around, and I began to realize that the delay problem was far more endemic and far earlier. There were these incredibly lengthy waits after arrest to see a judge or a lawyer. So in my experience, the world ran like this. You got a prompt court appearance, Rule 5 of the federal rules. What happened there? A judge gave you an exhaustive advice of rights. There was probably an interpreter. You had a lawyer. A lawyer was there from the very beginning. Often even before you walked into court, a lawyer had spoken to you, was prepared to explain what was happening and to make bail arguments. As a result, orders of release were fairly common. Even if you couldn't meet the conditions right away, it was understood that counsel's job was to make arguments and therefore had to be prepared. What I discovered was that people weren't having prompt court appearances. They could wait for days or weeks. In our initial appearance report, we talk about one woman who waited 96 days for her first court appearance. There was often no advice of rights, or if there was advice of rights, it omitted the right to counsel. That was convenient, or it was delivered by videotape, or it was only provided in English. The assistance of counsel largely didn't exist. It wasn't just that there wasn't a lawyer present, but frequently a lawyer was not assigned. And here I'm not just talking about whether a lawyer was assigned reasonably close to the initial appearance as required by Rothgary 2008 case, but many places, including New Orleans, where the practice was simply not to appoint counsel until a case was indicted, making that very long gap between arrest and indictment or arrest and information even more problematic. And as a result, of course, you had extended pretrial detentions, which lead to coerced plea bargains, devastatingly bad outcomes for defendants. So what do you do with that? You know, this is a really challenging problem for anybody, but it's a particularly challenging problem if you're just one person and you're trying to think about it. Unfortunately, I didn't have to be just one person, but I was the person sitting there saying, look, we've got all of this empirical research that early access to counsel matters, that release on bail matters. We have constitutional law beginning in 2008 that says, nope, you don't have to wait till indictment. The right to counsel attaches at initial appearance, and counsel must be appointed within a reasonable time. Now, we're going to talk about why that's not right. Probably should be counsel must be appointed at the initial appearance and be present, but still, that was progress. And yet, you have this wildly underregulated procedure where between arrest and formal charging, whether by indictment or information, there are no guardrails. There are no limitations. And here I want to stress Gerstein, right, in County of Riverside, which say you have to have a probable cause determination, right, promptly. Do not say that 48 hours for the probable cause determination is not the same as saying that the probable cause determination must be made in court. And of course, it doesn't even apply to people who were arrested on a warrant. The reality is there are no guardrails for guaranteeing a prompt initial appearance or a timely decision about whether your case will be prosecuted. So I was incredibly lucky. We have wonderful partners who believe in funding research for reform. And thanks to the partnership of Arnold Ventures and the Charles Koch Foundation, we were able to build a campaign that was interdisciplinary, that was focused on people and practice and systems, and that was designed to create actionable steps for reform. So we have this great team. Me, I'm mostly along for the ride. It's a labor of love, but although it kind of broke my heart, I had the privilege in February of handing the reins of this project over to Malia Brink, who many of you will know. I can't imagine anyone who would have made it, who would have been happier to give this to. Most of you will know Malia. She came to the Deason Center in February just to work on this project. Previously, she was the staff counsel at SCLADE, the Standing Committee on Legal Aid and Indigent Defense at the ABA. Before that, she was at the National Association for Criminal Defense Lawyers. She's been an ACLU lawyer. She is as well an expert on caseload studies and right now working on the very important meta study on caseloads, which I'm sure you'll all either have been hearing about or will be hearing more about. Jiacheng Yu is a policy attorney in our office. She joined us in January to work on this project, and she focuses on the initial appearance piece of this project. After she graduated from Yale, Jiacheng became a public defender at CPCS, parenthetically my old stomping grounds, for at least a little while. She's also been a public defender in Dallas County, a clinical fellow at the SMU Law Clinics, and joins us again as a policy attorney. And I can't wait for her to kind of make her national debut with this presentation today. Shem Vinton is our other policy attorney. Shem can't be with us today, but the reason he's not tells you a little bit about who he is. Before Shem even went to law school, he was in the U.S. Armed Forces. He's away this week doing his 2-week annual training for his reserve duty. But Shem comes to us from the Nueces County District Attorney's Office. That's Corpus Christi, which I think many of you will recognize as a progressive prosecutor's office, where he worked on issues of intake and charging, which makes him particularly well suited for what he's doing, which is running the pieces of our program here that revolve around prosecutorial decision-making. And last, but certainly not least, I want to introduce you to Blaine Skiles, who's our amazing communications director. He works with our graphic design team, InfoNewt, to create all these wonderful presentations and reports. And I want to say here that, one, we're incredibly lucky to have him, won an Edward R. Murrow Award, among other things. But two, Blaine's role in this project is to help us make this project work for you, which means that everything you're going to see today in this presentation, all of our graphics, everything you see online, don't bother trying to cut and paste them for yourselves. Reach out to us. We plan to help you use these tools to make tailored reports, one-pagers, documents, slides that reflect your needs and your advocacy campaigns. He's your man. So that is our wonderful team. Of course, none of this would work as well without our amazing advisory board. Again, I don't know how I got to be this lucky, but this is a team of superstars. You could not put together a better dream team to work on these really important due process issues from all areas of the criminal legal system, from all perspectives on politics and advocacy. We are so lucky to have this amazing advisory board. In terms of what this project looks like, let me say a couple of words about what Research for Reform means in this space. Research for Reform here, yes, it's about initial appearance and charging time, and we've broken it down into those two areas. But, there's more to be said here. This project really lives at the nexus of due process and the right to counsel. What do I mean? Well, for example, on the charging time space, we all know as a basic matter of due process, you can't hold somebody in custody, for example, who's incompetent and say, I want to charge them with a crime, unless you're planning to restore them to competence and you're actively working on it. Jackson versus Indiana. We don't allow the police in this country, in theory, to pick people up and disappear them. And yet we have this kind of weird gap in the law where people can wait in jail in many states indefinitely, right, without ever being indicted or seeing a lawyer. And so the right to counsel comes in here because bringing a lawyer into the process, we know, is one way to actively combat that omission. There's a really important intersection here with the bail reform movement. Bail reform is terrific, but you can't have a bond decision that's informed and meaningful if you can't get to court. And so to talk about bail reform without talking about the need for a prompt initial appearance with the assistance of counsel doesn't make any sense to us. What else can I say? We are building here on the incredibly important work that many of the people on this webinar have already done on having early access to counsel. I'm talking about people who've done empirical work and people who've done litigation. That work on early access to counsel and counsel at first appearance is a cornerstone of what we're building here. And last, but certainly not least, we are sharpening a focus on a conversation about pre-charge process rather than pre-trial process. We talk about pre-trial process, but the reality is that's kind of silly in the sense that almost nobody has a trial. And everything that matters for most people happens between their arrest and the day that the prosecutor makes a charging decision. That's going to determine what happens in your case. And so our goal here is not only to help change the law about initial appearance and charging time, change the practices around initial appearance and charging time, but to shift the conversation to really hone in on where we think there's impact to be had at that nexus of due process and the right to counsel. So, Research for Reform, that's what it means to us. And with that, I'm going to hand it off to Malia Brink, who's going to take it from here and explain the problem.
Thank you, Pam. As Pam said, I joined the Deason Center in February to direct this project, and I am so excited to share this important research with you all today. My immediate task is to provide an overview of our project and focusing on the initial appearance aspect, which we're going to discuss today. Like all of what the Deason Center does, the goals of our initial appearance project are twofold: research and reform, research for reform. The research is to understand the problem in all of its complexity, what drives it, what could prevent it, and to start to do that in 2021, late 2021. The Deason Center released this report, Ending Injustice, Solving the Initial Appearance Crisis. This report talks extensively about the harms of when initial appearance is delayed, counsel is not provided, and by identifying those harms also begins the process of identifying solutions. I hope if you've not had a chance to do so, you will take a look at this report because it is really our starting place. From there, we want to understand and explain the law. Having begun to identify practices and potential solutions, we're going to conduct a far deeper dive into what part of the initial appearance process is dictated by the law. And that is building, I want to credit here what Pam Metzger and her colleague, Jancy Hofel, published 2 law review articles, one on initial appearance and one on charging time. And they explore the constitutional framework and questions around these processes and legal avenues for redressing them. Unlike their work, our work, this brings us right to today. These report cards explore the law on initial appearance for this broader audience of you all, reform advocates, policymakers, criminal justice system players. Looking at these laws provides tremendous information about the guardrails that exist and that could exist, right? Looking for models within the law. It also demonstrates the immense lack of those guardrails, the law that doesn't exist. And I want to pause for a moment because anyone who's tried to do a 50-state study of anything probably knows that it is not easy. This represented the second or third time that the Deason Center has done a deep dive into initial appearance law, and that is in part because much of this law does not exist. All lawyers know that trying to prove a negative is an almost impossible task, but I want to start us off by saying that is the reality here. More often than not, the law that we might be looking for does not exist. In thinking about the report cards and looking through the law on initial appearance, our first task was to try and figure out, how do you grade these states? What are the best legal practices that we want to judge this law against? And in doing that and looking at all the law across all the jurisdictions, we came up with 5 categories of legal protections we really thought ought to exist. And those became our 5 legal best practices against which we graded all of our jurisdictions' law. The first of these set forth the basic structure for an initial appearance. And just to emphasize, we're talking about people who are arrested and held until initial appearance. So as we move through the process, I just want to make clear that at almost every stage, we're talking about people who remain detained. That's not to take away from the need to provide quick process and access to counsel for those who are not detained, but rather just as a point of emphasis and a starting place, starting with those who we think most need assistance, and those are the people who are sitting in jail. So our 3 process recommendations: 1, initial appearance should be held within 24 hours. The second, that there should be counsel at initial appearance. And the third, that defense counsel should be appointed within 72 hours. Our 2 other best legal practices are remedial in nature. They're designed to verify that these first 3 happened correctly or provide relief if they did not. They are that a delay in initial appearance requires release, and that if you remain detained following initial appearance, you receive a prompt review. So now I'm going to walk through each of these in a little more detail. What does it mean, held within 24 hours? This is a prospect of timing. Simply put, does the person who's been arrested and jailed have a right to be brought before a judicial officer within 24 hours of arrest? Now, I want to pause because I know any of you who know me probably know exactly where this leads, that the prospect of timing, which involves holding initial appearance on weekends and holidays, probably immediately raises a concern of virtual proceedings. holding those proceedings online or over a phone or some other way other than in person. Those of you who know me through my ABA work know that I'm personally very skeptical of virtual proceedings and concerned about the dehumanizing effect. But in this instance, in terms of our best legal practices, we only focused on timing. Is it held within 24 hours? Counsel at initial appearance. Must the court provide an attorney to represent a person at initial appearance who does not appear with private counsel? This question is only about representation at initial appearance, so appointment of an attorney of the day or a duty lawyer for our purposes complies with this best legal practice. Defense counsel within 72 hours. Having allowed the idea of a duty attorney, this becomes even more important. Within 72 hours of arrest, must an attorney be appointed to defend the case at all further stages of the prosecution? So if you allow for the idea of a duty attorney, is the person who's going to defend the rest of the case appointed and ideally in place within 72 hours? So the arrested person, we know the importance of this, needs to begin building a relationship with their defense counsel, and defense counsel needs to begin investigation. Also, in a slight foreshadowing of our work on charging time, I will say that the other process that's going on here, which is this decision to charge, if we can get that defense counsel in and guaranteed within 72 hours, that person can impact that charging process as well. Ensuring appointment of counsel can happen in a couple ways. The law can specify either that the initial appearance attorney continues on the case, or that the defense counsel will be appointed or must enter an appearance within 72 hours. Delay requires release is pretty simple. If the person is not given a timely initial appearance, will they automatically be released from jail? If you look at the case law on delaying initial appearance, it's almost always about coercive delay. Law enforcement seeking to delay initial appearance to prolong interrogation or prolong sitting in jail prior to interrogation. Our belief is that the law should be simple. Initial appearance occurs timely or a person is released. And finally, prompt review if detained. So if a person has an initial appearance and remains in jail, is there an automatic hearing held within 72 hours at which a defense lawyer can revisit conditions of release? This hearing has several purposes for anyone who remains detained. If it required a transition from a duty lawyer at initial appearance to a defense lawyer, has that defense lawyer been appropriately appointed and engaged? So it serves to ensure that appointment and that transition. It also serves to revisit conditions of release where the intent was that the conditions would be met, the person would get out and the person's still sitting in jail, and allows for modification of those conditions if needed. So these are the categories of our best legal practices against which we are going to judge our U.S. jurisdictions. Having introduced you to those parameters of our research, I'm now going to turn it over to my colleague, Jiacheng, to walk you through our report cards. Again, available on our website today, can be accessed through this QR code because, as Pam said, we got fancy. And Jiacheng is now going to walk you through our methodology and our jurisdiction by jurisdiction results. Jiacheng?
Thank you, Malia. So happy to be here today to talk about the methodology behind our research, how we came up with these grades, and why your state got the grade that it got. As Malia stated, in order to take the next step in advocacy and litigation, it's so important for us to know where we are right now in the legal landscape. And so what we did is we looked at laws that are on the books for each state. And that includes statutes, that includes rules of criminal procedure, as well as case law. What we did not include is practice. If we included practice, this whole report card will be 5 times as thick and only about Texas, because we are a county by county system and we have 254 counties. And that does not give us a good indication of people's protections in the state, because regardless where you are in Texas, you should receive the same level of protection and due process at initial appearance. Now I'm going to go ahead and talk about how we were able to attach a letter grade to every state. There are 5 categories of best legal practices, and each category you could score 2 points. If the jurisdiction adopted the best legal practice in its law, then the jurisdiction's rated as a yes and received 2 points. If the jurisdiction adopted some of the best legal practice, the response is a limited, color-coded by yellow, and the jurisdiction receives 1 point. And if the best legal practice simply does not exist in the jurisdiction, then 0 points. The highest amount of point you can receive is 10 points. And we rank that in a simple numeric conversion to letter grade. And that's how everybody received their score. Now let's go ahead and look at an actual example of a report card. We have 54 of these, one for every jurisdiction. And we wanted to show you Maryland first because Maryland got the highest score of all the jurisdictions. On top of every page, you will see that we have a color wheel that summarizes what the report card presents. Maryland got a B. Yes, the B was the highest score that any jurisdiction received. But you can see it has 3 yeses, 1 limited, and 1 no. So there's a lot of green and very little red. After, for the rest of the page, we put in details about each of the categories. If there is a yes or limited rating, we also put in the citation of where we received the information, and sometimes a short explanation about how we interpreted, how we interpret the law. And if there's a no rating, as here in category 4, unfortunately, there's not often a cite because the law simply does not exist in that jurisdiction. Here's another example of a report card, which is New York, which received a C rating. As you can see, there's less green and more red in our summary circle. I wanted to use New York because it has an extra feature that Maryland did not have. If you look on the bottom of the report card, there is a little note section marked by an exclamation point. This is where we put interesting and unique facts about each state that we felt was really important and noteworthy. So we added on the report. Not every state has one of these, but New York does have one. But no report review is complete without looking at someone who did not do as well. And for that, we chose my home state of Texas. As you can see, we got an F. Out of 5 categories, there was only 1 limited. So the whole page was very red. That means we have a lot of space and need to improve. Now we're going to do a deep dive into each of the categories to tell you how we rated someone as a yes, a limited, and a no. Some of these are pretty self-explanatory, but some of these has a lot of nuances. Let's look at the first category, which is initial appearance being held within 24 hours. We'll start with an example of what happens when the 24-hour initial appearance is not in play. We're looking at Louisiana. Louisiana statute, it states that initial appearance must occur within 72 hours arrest, but it excludes weekends and holidays. As a result, those 3 days could become potentially a week-long detention before you ever see a judge. And here's an illustration. If you had the misfortune where your 72 hours include some weekends and holidays, you could be sitting in jail for a week. Now let's look at how we graded the rest of the states. Well, because Louisiana clearly got a no. Florida, if your state is like Florida and it has this rule or statute that clearly states you must have the initial appearance within 24 hours, you got a solid yes. However, most states are not like Florida. Most states are like Tennessee. Tennessee does not have a time limit. Tennessee only requires the initial appearance to occur without unnecessary delay. and there is no definition of it in the statute. In those cases, we dug into the case law to see did the court give us a parameter for when the initial appearance should happen. And most states like Tennessee decided to actively avoid the question and not set a strict boundary. So they get a no rating. And then we have states like West Virginia, where the court seem to indicate there's some kind of parameters. There is no time limit in West Virginia by statute, and without unnecessary delay is the rule of the land. However, during the deep dive, we realized that most litigation around unnecessary delay talked about delays that are within 24 hours. And many cases actually ruled that less than 24-hour delay was unnecessary delay. As a result, we put West Virginia as a limited to reflect this tendency to favor 24-hour appearances. Next up, we have counsel at initial appearance. And this, as Pam and Malia both mentioned, this is whether or not a lawyer is going to be there to speak with you, to explain to you what's going on, and to do a bail argument for you. This one was a little bit more difficult to grade than the 24-hour requirement. And we only gave yes to states with extremely clear-cut statutes that provide right to counsel at initial appearance. Delaware, for example, their right to counsel statutes specifically states the defendant is entitled to have counsel assigned to represent them at every stage of the proceeding from initial appearance through appeal. That for us is a solid yes. Most states, however, are not like Delaware. They're more like Arizona. In our no states, the statute simply says that a judicial officer will inform you or advise you that you have a right to counsel. Some go a little step further and say that a judicial officer shall appoint counsel for you at initial appearance, but it doesn't say anything about whether or not there will be a person actually representing you at initial appearance. For us, that is still a no. Third category is defense counsel within 72 hours of arrest. As Malia mentioned earlier, the reality is that in most states that provide counsel at initial appearance, it's that attorney you see at initial appearance might not be your attorney later on in the proceedings. You could be, let me just give you an example. I think that's easier. I practice in Massachusetts, and as a public defender there, we did not have 24-hour initial appearance, but we did have counsel at initial appearance. And I would be the duty attorney for the day. I will go and represent everybody on the initial appearance docket that was arrested last night, and unless there's a conflict, of course. Then I keep some of these cases, but some of the cases get distributed to the other attorneys in our office. And here comes the gray area. The statute doesn't say anything or account for the fact that I might not keep the case after initial appearance. Our office would have been in no legal trouble if we waited several days before appointing counsel, which was not what happened, but that gray area, it exists in almost every state. And that gray area could create a potential large gap in representation between your initial appearance counsel and your defense counsel. As a result, Massachusetts was rated as a limited because the law doesn't say who is going to be on the record later on. And that takes us to a special case of Texas. I know we only got one limited, but it's a pretty important limited. In Texas, we don't have initial appearance within 24 hours, nor do we have counsel at initial appearance. But we do have this little provision in the Code of Criminal Procedures that give you a deadline for the appointment of counsel. and it is 1 to 3 business days after you request that appointment. Essentially, metropolitan areas that have big jurisdictions that have more lawyers gets 1 business days after request to appoint you someone, and smaller, often rural jurisdictions gets extra 2 business days, so 3 business days. Now, 1 to 3 business days clearly falls outside of the 72-hour limit that we impose. That's why Texas received a limited rating, but it's a good example that you can set limits for when defense counsel is appointed to keep everybody accountable for the appointment. The fourth one, we have whether or not you will be released from custody if your initial appearance is not timely. This is one of our 2 remedial measures to preserve people's rights when something happens, something goes wrong with the first 3. And we anticipated very few states will have a release statute like this, but we did find a couple, one of them being Arizona. Arizona, if you do not have an initial appearance within 24 hours, you should be immediately released from custody. And then there are limited jurisdictions like Minnesota where that is provided to some folks. In Minnesota, if you're charged with a misdemeanor and does not receive a timely initial appearance, you must be released. But other than, the yes and the limited together still makes a minority of states that have anything akin to this rule. And last but not least is whether or not you receive a prompt detention review if you remain detained after initial appearance. And Malia discussed this earlier. We want 4 things. We want this review to be automatic. We want it to be a full hearing. We want it to happen within 72 hours of initial appearance, and we want counsel. And when we started the research, we weren't sure if we're going to find any states that do all 4 of these things. But we found one. Good job, Maryland. In Maryland, you do get a de novo review if you are detained after initial appearance. Happens at the next court session, which is generally within 72 hours. And you will get counsel. The statute specifically provides that the public defender's office will represent you if needed. There are a bunch of other states that we rated as limited. They are very, very, very limited. As you can see in the case of North Dakota, it's not automatic because you have to request it. The law is unclear whether or not it's a full hearing. The law is unclear whether or not you will have counsel, and the law is unclear when that hearing will happen. However, we wanted to include these limited states because there is to show states that there are provisions that's already in your code. It's already there. All you have to do is make it better. I'm going to very soon turn over to Malia to talk about assessing the results and some trends, current and future trends, initial appearance. We're really excited about these report cards. We want this to allow folks to compare practices across jurisdictions and see where you can find rooms for improvements, find best practices in your neighbors. We also want folks to be able to see, hey, I have good law on the books in my state, but it's not in practice, and maybe there's something we can do about that. With that, I'm going to turn it over to Malia to talk more about the results.
Thank you, Jiacheng. I'm going to walk you through the aggregated results of our research, both overall and by category, and discuss some observations and trends. Before I do, I just want to observe that there are really no political or geographical patterns to the jurisdictions that have the appropriate legal protections or more of the appropriate legal protections and those that don't. So if we're looking at this map of our overall results, you'll see coastal states, some do well, some do very poorly. Heartland states, some do well, others do not. The politically red states, some do well and some do poorly, and the same is true of politically blue states. Even among our islands, there are a full range of results. So I want to walk you through aggregated results by category. Is initial appearance held within 24 hours? As a reminder here, our green states have a clear 24-hour requirement, while our yellow states either have some exception or the 24 hours is based on case law that is either a little older or just a little not clear that there's a strict limit. The vast majority of states do not require initial appearance to be held within 24 hours. The far more common is 48 or 72 hours with exceptions for weekends and holidays. Again, no real observable geographic or political pattern among the states. For counsel at initial appearance, this is the one where there is the most success in the law at providing appropriate protections. You have 27 states with counsel at initial appearance, one limited that's Ohio, but it's not very limited. It's 6 months plus. So, I mean, it's really close. One thing that I did want to note is, well, a couple things. One, a lot of these are new states. Counsel at initial appearance has been gaining traction in the last couple of years. And I draw your attention to some of those new states like Michigan and Nevada. And I would say that it's pretty apparent that that comes along with a wider range of indigent defense reform that's being pursued in those states. The other point I would like to make is when we looked at this and we set up our 5 best legal practices, I kind of assumed that there would be an inherent tension between having a quick initial appearance, that requirement of 24 hours, and counsel at initial appearance. But in fact, 6 of the 10 states that have a 24-hour or close to a 24-hour requirement for initial appearance have also counsel at initial appearance. And that's that asterisk that you see: Delaware, Florida, Iowa, New York, West Virginia. So that tension about timing is really not the issue. Defense counsel within 72 hours. This really reflects the lack of clarity in the law on this point. There are no green states. I think our work has really emphasized a need for a guarantee here. I also think you're seeing that in kind of the reform litigation that's going on. Lack of a statutory requirement on appointment of defense counsel promptly is one of the ways that contributes to you getting waitlist, right? We're very aware of the waitlist litigation out there as a solution to public defense backlogs and excessive workloads, as opposed to the real solutions of additional resources and funding. And so this, I think, it really reflects a critical area of need for reform. In terms of the delay requirements, very few states have these requirements. Jiacheng actually mentioned that this is a really necessary remedy. If you look at courts that are looking at delay, you often find delays are not held to violate rights or be substantial, even when significant: 30, 45, 90 days. We go through some of those in the initial appearance report that I encourage you to read. Again, simple remedial step. I will kind of preview some of our policy work and say that when you talk to places that have this requirement, they don't use it. It's an effective deterrent for failing to provide initial appearance. They just have initial appearance. And then prompt review if detained. Numerous states have some form of review, right? Jiacheng mentioned that often these reviews require a request. This is a particularly concerning aspect of the legal requirement, to the extent that we view this as one of the ways to ensure that defense counsel is actually promptly engaged. If you have to make a request and you're trying to do that without defense counsel, there's no possibility of a real request is going to be made. They should be automatic, and they should be not only about verifying that conditions of release are appropriate and that people are getting out, but also that counsel is in place. So back to our map, just as kind of a final view of the current state of the law. And then I want to talk a little about where we go from here. So before I took you through step 1 and step 2 of our project, explain the problem, explain the law. Now that we have this explanation, what are we going to do with it? We did not build this to sit on a shelf. We built it to be useful. So our next step is to develop policy guidance. In the next month, we're going to be releasing a policy paper on initial appearance that goes more in depth about what the law should be, what practices should be, and talking about examples of places with very good law or practices that can serve as models. We're then going to transition completely to advocacy, trying to put this reform into action. We plan to look at different aspects of reform. One of the things that came up in our research is how integral the rules of criminal procedure are to this. Oftentimes, the Rule 44, which is used in a lot of states, it either says you have right to counsel from initial appearance through appeal, or it's vague, which allows you to evade counsel at initial appearance. Changing those rules could be a much more direct and easy way to achieve reform. And so that is something that we are looking at. Oftentimes those rules are revised by Supreme Court committees, which may be an easier route than either legislative or litigation reform. And so we are interested in that. We are also interested in pursuing statutory and litigation-based reform. So whether that is through legislation or through litigation. In the course of this, we have learned a lot about what is going on in the country. We would like to learn more, but we picked up on some litigation concerning failure to provide counsel at initial appearance in Arkansas, where the rule is pretty clear that it's required, and we are starting to do our work to support that litigation and advocacy effort in that state. And I want to talk a little bit about how you can help. Cannot emphasize enough. Our goal is not to put out this report and just have it be informative. We want it to be helpful to you, but you can also help us. So teach us more. I am not at all above taking a second look if you think we got something wrong. This is hard work. And also we want to know about what's happening in your jurisdiction. If there's a movement for reform, if there's an avenue that you see for reform, please come and talk to us. Ask us for assistance. Pam mentioned at the start that we are planning to develop tailored versions of these reports and policy papers for jurisdictions. That is what we want to do. If we can be of assistance to you as you pursue different advocacy efforts, please call upon us. We want all of this information and data and all this work that we've done and all of our absolutely beautiful images created by our comms team to be out there and being used. So please call upon us if we can be helpful. And with that, I'm going to turn it back to Pam for questions.
Thanks, Malia. Some of you have already weighed in, either telling us you think we screwed it up or telling us what's happening in your jurisdictions. And as Malia said, we get it wrong. It's happened before, it'll happen again. So please do let us know. What I do want to let you guys know is we have time open for questions and answers. We can jump into the report cards a little more. We can talk about the advocacy that we're available to do with you. We can tell you a little more about where we see this campaign going. But we want to open the floor up for you and for some feedback. I do want to answer a question on the webinar that I got in the chat, which was whether this was going to be shared afterwards. The recording is going to be put up on our YouTube channel. So you can go there. Again, we're very fancy. The report cards and the initial appearance report are up online. If it's not already there, very soon there will be a map online that you can click that will immediately take you to your state's report card. So we'll have it available in multiple formats. And again, we will be able to, if you reach out and you want our help making a version of this report that's tailored, a version of our initial appearance report that uses the report card that's tailored to your state, reach out. We are looking right now at candidates for reform. In other words, looking at jurisdictions where we're going to do very intensive partnerships. And so we're eager, obviously, to do this with the experts, and that's y'all.
Right. And Pam, I just want to add, this was very intentionally done with one state per page so that a one pager is a very easy pullable thing. We already have a version of our methodology for the back of that page. If that is useful in any state, please reach out.
So I'm shocked that this is a shy audience. I know most of you. I taught some of you. I don't think you're shy. But let me just point out something, a question that Joanna Landau just asked, which I think is a great one and points to this question of reform. Joanna asked whether there's any correlation between jurisdictions that require counsel at first appearance and the way in which public defender systems are operated. In particular, whether these are state-run systems or systems in which it's delegated to county governments or local governments. We have not asked that question, but that's really, again, the beauty of these report cards and all the hard work that Malia and her team did, is that's a question we can answer now, right? It's very easy for us to just pick up one question at a time, look at the trends, and then turn to this question of how public defender systems are organized, look at questions of independence, look at questions of funding. We're actually, if you look at the report cards themselves, we've called this grading injustice. And the reason is because we plan to do a series of these. And I think the beauty of trying to come up with some clear, simple legal rules, as opposed to practice characteristics, which I realize are very different than legal rules. But if we establish what the legal rules are in each place, and we have some clear characteristics, it then becomes very easy to look for those kinds of correlations. So the question that Joanna asked, and I suspect questions that others of you may have, are exactly the things we want to hear about. Where are there connections that we may have missed, for example, in questions about the delivery of services and how that might be connected to the legal structures that confine or expand the services that are delivered. If that makes any sense. Malia, do you want to say anything about that?
I mean, I agree. I think that one thing I would say is that I think that in places that have kind of a public defense system, the instinct, and this goes to particularly to the issue of defense counsel within 72 hours, is to not kind of intrude on the process, that was left kind of to public defenders to figure out how to get that assignment and get it in place in any sort of timely fashion. I don't, one thing I would like to add is just that I don't think we want to intrude on that, and that one of the ways that you can have a requirement without intruding kind of directly into practice and process is to just require entry of appearance. And so that's the only piece I would add. I haven't looked at like the public defender, the statewide systems, or even statewide funding to try and figure out if any of these directly correlate with that.
Thanks, Malia. I want to jump to a great question that Dana Eddy just asked about definitions and terms. Dana's question, I'll just read it for the group because I'm not fancy enough to know whether y'all can see it, is that there may be some language issues. In West Virginia, a person is presented to a magistrate where bail is set without appearance by a prosecutor or defense counsel, which I would like to change. The appointment of counsel is guaranteed for the formal arraignment before the magistrate, which seems to be conflated with first appearance and presentment. Definitions would be helpful for the analysis. So our report, our initial appearance report, I think does set out some of those definitions. If we haven't done it clearly enough, we'll go back and take another look. But I can tell you how we define first or initial appearance. We define that as the first moment that a person appears in front of a judge. It doesn't matter what else happens. In other words, if you have, there are places that, I think it's North Carolina, where you have both a first appearance and an initial appearance, which feels like a redundancy. Texas, we have something called magistration. What arraignment means everywhere is very different. For our purposes, initial appearance is the first time a person sees a judge, period, full stop. So there are people who have their initial appearance when they appear and are arraigned on an indictment, if you're a direct indict. There are people who have an initial appearance when they're picked up on an arrest warrant. It doesn't, for purposes of this inquiry, our recommendation is that the first time a person sees a judge or judicial officer after arrest, that is the initial appearance that we're talking about, and they should have the assistance of a lawyer at that first judicial contact. So thanks for the great question, and hopefully that helps.
Yeah, and we'll look at it again because it is confusing. I just to give some examples of that and what makes this so confusing. So in New Hampshire, for example, if you're arrested and your bail is not set in your arrest warrant, or you're arrested without a warrant, you have a right to call a bail commissioner. You don't have to use it, but you can call a bail commissioner and get bail set. As an aside, that process costs you $40. And it's just a phone call to a bail commissioner to set bail. Supposedly the fee is waivable for people who are indigent. But is that an initial appearance, right? I mean, it's just a phone call. It may not even happen. It's a bail commissioner. There's then an initial appearance. This is what I mean when I said these are hard questions. I don't think there are two states that do this similarly. I'm pretty sure that within most states it's done differently from county to county in a lot of places. And it makes this inquiry incredibly complex. We've tried to present it as simply as possible, but it is not simple. And every single day things are happening that compound it. By way of another example, in Nevada, they tried to pass a reform because they wanted people to be getting access to ability to get out earlier. And while initial appearance is within 72 hours, starting in July, they started a kind of 48-hour bail proceeding. And the interaction between that and initial appearance is still not completely clear. So we're you know, all these are all moving targets, and we are very interested to learn more. So keep sending that stuff in. I know, Pam, you have a couple more questions.
Yes, I want to kind of take these, I think, in reverse order. I got a question from our friends in North Dakota about whether there was questions about duty attorneys at initial appearance and how that kind of conflicts with the preference for vertical representation. So this is something that Jancy Hopeful and I wrote about in our article. This is something we talk about in our report, the full initial appearance report. And I think this is someplace where Malia and I think we're in agreement here, although again, there's a diversity of opinions out there in our community. I think we both are of the view that purely vertical representation is almost an impossibility if you're also going to comply with other best practices. And what I mean by that is, even if you had a fully staffed office that had access to defendants before initial appearance, at initial appearance, it would still be the case that there are some circumstances where an initial interview with a client is going to tell you that they need a different kind of lawyer. They need a more experienced lawyer, that the charges filed don't fully capture what you need to know who is the right lawyer. So I don't know that it always makes sense. And again, this is my view. I don't know that it always makes sense to talk about vertical per se. I think our sense internally is that what makes sense is to talk about initial appearance and vertical, recognizing that it would be lovely if you can have purely vertical. But again, you know, if you're a defendant, out is out. And so if you ask, I think almost any of our clients, whether they'd rather wait to have the right lawyer assigned for the whole time or have a duty lawyer represent them so they can go home and then get their lawyer, I think we all know which one they'd pick. That's the reason, though, that we honed in not just on whether you have counsel at initial appearance, but on how quickly you are provided with a lawyer who is starting to work to defend the case. What you see in many, many places where there are wait lists, Wisconsin is one that immediately comes to mind, and I know there's litigation there now. Everybody has a lawyer at initial appearance, pretty much, right? And then they wait, you know, weeks, months, sometimes even longer, for a lawyer to be assigned to actually defend them. And so, you know, that's the place where that 72-hour rule for how long does it take to get the lawyer who's gonna defend your case started. And although we don't deal with it in the report cards, because they're very much about law, not practice, our initial appearance report, the full report, talks about the importance of there being continuity in representation. In other words, it is a best practice that the duty lawyer represents the defendant until the long-term defense counsel comes in. There should not be a gap in representation, right? The duty lawyer has to be more than a warm body in a courtroom for a single day. let me ask Malia if she wants to comment at all on that. I suspect
Right.
she does.
Well, and there are places that have that statute, that have that example statute where you're appointing a duty lawyer and it requires continuity until that person is effectively replaced by defense counsel. A lot of places that continuity rule doesn't have a timing, right? And that's a huge part of the problem. I would just add that I think we're reflecting back on what practices are. Increasingly, you are seeing bail units. Part of that is an effort to get counsel. Part of that came with the wave of trying to get counsel at initial appearance, and recognizing that if you're both trying to do that and you're trying to make sure initial appearance happens quickly, that you're trying to provide vertical representation when you're doing initial appearance on a holiday is going to be almost impossible. And I just want to stress one of the points that Pam made, which is it's often at that initial appearance at that conversation with the duty lawyer that you actually can assess the type of lawyer needed, right? Do you need someone from the mental health division? Do you need someone, is this case most likely going to end up in your sex crimes unit, right? That's the place where you're going to be able to assess exactly the type of lawyer. And so getting that person to the right lawyer quickly may be part of what happens by appointing counsel at initial appearance.
We also have a question here about whether we need a federal remedy and is a policy in the works. And so the quick answer here is that the problem in many ways starts with a lack of clarity in the United States Constitution. We expect the Constitution to be a floor. The problem is that there's kind of nothing. It's more like you're standing at the top of an elevator shaft at this point. If you look at the case law on initial appearance delays, there are courts that have said that delays of 2 and 3 months don't violate the Constitution, or that any constitutional error that might have existed was simply obviated by the fact that someone took a guilty plea. The same is true for the appointment of counsel, even after Rothgary, because Rothgary only says a reasonable time after initial appearance, and because of the Alito concurrence, which says that he does not understand Rothgary to mean that you have the right to a private investigator before indictment. There are courts that hold that there is no clearly established constitutional right to have counsel within any particular time. And so there are judicial opinions that say that it is not a constitutional violation to wait 6 weeks in a capital case, in a murder case, for counsel to be appointed. So would a federal solution be great? Sure. But that's only going to happen if it's litigated. And this is not a court that I'd bet my bottom dollar on. Although we are going to be doing some litigation, and we plan to build a litigation team that will support us on that. Our goal is really to move the law first, because I think most folks on this call would agree that at this point, you're going to be more effective in achieving reform in arguing that a state law has been violated than that an unarticulated constitutional principle hasn't been complied with. I'm going to jump to Travis's question, and Travis, you can ask as many questions as you want. Travis says that they're having questions and concerns about amendments to Rule 44 and more clarity. And there've been lots of concerns about a conflicts check to avoid ethical pitfalls. And he wants to know if we found anything on initial appearance representation by a duty lawyer and conflicts. I have this vague recollection that Washington State may have said something in their rules about conflicts, but I can't remember for sure. Malia, Jiacheng, do you remember off the top of your head what we found out about that?
No, I remember discussing it a lot and thinking through kind of the guidance and practice that you could use to potentially insulate a duty lawyer from knowing more about the substance of the case. But no, I don't remember actually seeing anything that would provide additional clarity. Jiacheng?
Yeah, I don't recall anything off the top of my head, but we can look into it a bit more.
And I don't know, Bob, if you're on here, there he is. I think he answered before I could ask, but Bob would have had something on there. I knew it. But this is a really incredibly important question. And it's another reason why I think, Travis, it's important not to tie ourselves to verticality in ways that are counterproductive. And so if you're going to insist on vertical, I don't mean you personally, but if we as a defense advocacy community insist on verticality, that really is a long potential delay in the assignment of counsel. And the more rural the jurisdiction, the more likely that is. And so if we're going to insist on verticality at the expense of rapid assistance of counsel, what it means is that someone's going to sit in jail for a very long time while we wait for a conflict-free lawyer. As far as the question I think that you're particularly asking about is what happens when you have one duty lawyer and 2 or 3 or 4 defendants? Yeah. And how does that lawyer represent them all appropriately at the initial appearance without being conflicted out? That's a question I don't have a great answer for. And the reason is because in most places, you know, following Salerno in particular, the strength of the government's case is a factor that you consider in setting the bond, right? And it's first a criteria in deciding whether there's going to be detention or bond. And it's also a decision in what the bond's going to be set at. I think it's inevitable that if you have multiple defendants and you want to make a strength of the evidence argument, there is going to be a conflict, right? And I don't know that you can ask lawyers to ignore that. This is one of those places, again, where I think you got to ask, how do we make sure we're not letting the perfect be the enemy of the good? So like Malia, I am enormously skeptical about the wisdom of supplanting live in-person appearances and meetings with remote interactions. And at the same time, I would rather have someone have a timely remote initial appearance, meaning where the lawyer is remote and the defendant is not in the same room with them, followed up by that 72-hour review hearing that we talked about, where there is a lawyer present to check in, then have someone who is conflicted hold back in making a bond argument. And, you know, I don't have a great solution for it. I mean, the answer is probably, yeah. But I mean, if you're in a big urban area like Seattle, where you have 4 separate independent divisions of a single public defense delivery system, plus some private appointed counsel, they rotate. That's not going to work so well in most of North Dakota. And so, again, I think our decision after a lot of research and a lot of conversations was to think about this in 2 stages. The priority being making sure that people don't disappear after arrest. In other words, you have to see a judge within 24 hours and there has to be a lawyer there with you, representing you. And to set what we believe to be a realistic timeline that we believe should be legally mandatory, right? To find the right lawyer, assign them to the case, and have them start working on it. And that's kind of our vision. So, you know, what would be a best practice in North Dakota, given, I mean, you and I've mapped what lawyering looks like in North Dakota. Y'all ever want to see, we have really cool maps about where the criminal lawyers are and who takes appointments. The reality is you're probably going to have 1 live lawyer and some remote lawyers, and the remote lawyers are going to have to keep on being the defendant's lawyer until a long-term lawyer is appointed. And I think, in my opinion, that's a better practice than having someone try and make a conflicted argument about bail. Long answer, I'm sorry. That's what you get with me. Bob, anything else on this one? No. Okay. We are winding down. I want to be respectful of y'all's time, and we said we were only going to run until 3:15 Central. So what I want to just kind of reinforce in the long run is this. First of all, as I said, this is such hard work. You can't even figure out what the right name is for the procedure, let alone what each state's rules mean. They're buried, they're hidden. You know, you find all kinds of crazy things you didn't know existed. Our team, Malia and Jiacheng in particular, have just done an amazing job. I also want to thank Claire Buteau and Johanna Cousins, who provided just extraordinary research support. Johanna in particular, this is a testament to her tenacity and to my obsession. Johanna started working on this with me in 2014 when she was my student. I want to thank Arnold Ventures and the Charles Koch Foundation for believing that we could take on this complicated problem, and for believing that research has to be translated into reform. And most of all, I want to thank all of you who are here, and I want to encourage you, see us as a resource. This project was built to create reform. This project is staffed. I could not have asked for anyone better equipped to do this than Malia. Malia knows most of you. She has familiarity, deep familiarity with public defense infrastructure and judicial infrastructure in all US jurisdictions. And we want to be there with you to help you. We want to support your reform efforts. We want to know if you have reform moving forward that we can be supportive with. We want to help you develop materials. Again, reach out to us. We can help tailor reports. Our report cards are built so that we can create a one-pager for you that you can simply hand to your legislators. Let us know. We'll build one for you and send it to you. And we look forward to seeing you in the future. I do want to flag again, we have 2 exciting events coming up. One is a STAR criminal justice event where we're going to be talking about how to increase the diversity of criminal justice practitioners in small tribal and rural areas. The following day, we are hosting an IDRA event, the Indigent Defense Research Association, where we'll be talking about the importance of diversity and representation, particularly of impacted communities within the indigent defense research community. Look forward later this fall to us releasing a policy paper targeted toward lawmakers and rulemakers, addressing again initial appearance and right to counsel at initial appearance. And finally, look later in the fall to seeing our release of an analogous set of materials about charging time delays. We are so excited about this project. We're thrilled to be launching it and very grateful to have you all joining us, sharing your insights with us. And we are really looking forward to being your partners and your supporters and your cheerleaders in this incredibly important work.